Our last case for the day is Sparre versus State of Florida. You may proceed.
Thank you, Your Honor. Nada Carey, representing the appellant. There are two issues in this case. Both concern the problem of ensuring a reliable and proportionate sentence when the defendant chooses not to contest the death penalty or to waive mitigation. And the first issue, given that interest, it's our contention that the trial court abused its discretion in not hearing and considering the considerable mitigating evidence that was available at both the penalty phase and at the sentencing hearing.
Under our case law, what is a trial court's obligation when a defendant says that he or she does not want to present mitigating witnesses? What options does a trial judge have?
Well, the primary obligation of the trial court is to consider all possible mitigating evidence. Mm-hmm. And beyond that, the trial court must order a PSI. And in addition to that, if the trial court is alerted to the probability of significant mitigation, the trial court has the discretion to hear that evidence by calling persons with mitigation as its own witnesses or by appointing special counsel to do so. And in this case, the defense counsel's proffer of considerable mental health mitigation and other mitigation related to the defendant's background should have alerted the trial court to the probability of significant mitigation that it needed to consider in order to impose the death penalty in this case or to impose a sentence in this case.
Well, do you raise as an issue that there was, since we do require the trial court to consider mitigation that's in the record, that this, you're urging us to recede from Mohammed, but are you saying that there was mitigation in this record that the trial court did not consider, or that there was more mitigation that should have been presented and the trial court abused its discretion in not having someone present that?
The latter, Your Honor.
Okay.
I think under Mohammed, now of course in Mohammed the court was specifically looking at what the PSI might indicate. But in Mohammed, the PSI indicated considerable mental mitigation and records related to that, prior hospitalizations, et cetera. And when the court sent that back for resentencing, it gave the court discretion to obtain those records and hear the witnesses who would provide or present that mitigation whenever necessary. And under that principle, we're arguing that in this case, the witnesses were there. The trial court was aware that there were 4 mental health witnesses who were prepared to testify to 5 different psychiatric diagnoses of the defendant, prepared to testify that he had PTSD and a number of different psychiatric diagnoses, and also to the existence and applicability of both of the mental mitigating circumstances.
So what is the rule that you're now expounding? As I understand it, you want us to go further than Mohammed.
Well, I don't know if it really goes further. I think Mohammed, it was clear in Mohammed.
But you want us to require the trial judge, as opposed to giving the trial judge discretion, it sounds like to me. You want us to require the trial judge to call witnesses under what circumstances?
Well, okay, in my first issue, of course we got the second issue, but I'm assuming Your Honor's addressing the first issue. Mm-hmm. This court gave the trial court discretion. I think the problem is it's not clear what guides the trial court's discretion. Since Mohammed, the trial courts have sort of been all over the place here. And what I'm suggesting should guide the trial court's discretion is the rule set out in Mohammed, which is if the trial court is alerted to the probability of significant mitigation, the trial court must hear that evidence one way or another, either by appointing special counsel to present it or by calling those witnesses as court witnesses. discretion has to be guided by something. In this case, the witnesses were all there. They were waiting in the courtroom. They were available. And I don't think the trial court had the discretion to ignore that evidence that was readily available in the courtroom.
What did the trial court state? See, I guess there's nobody arguing that the trial court should have done. And we have a case tomorrow where the judge did appoint standby counsel and then to present mitigation. And I am concerned about the lack of guidelines. But what did the trial court say anything as to why he or she decided not to call the mental health experts that were there?
All we have really to look at is the sentencing order. The trial court stated in her sentencing order that she recognized she had discretion to call witnesses. Other than that, when she rejects a number of the proposed mitigating circumstances, including the mental mitigating circumstances, she states 3 or 4 different times, I recognize that Dr. Kropp had this testimony, Dr. Alligood had this testimony, Dr. Greenberg had this testimony, etc., but I'm not required to accept this based on a proffer.
But they actually, didn't the trial court say more, which was that in light of the way the scene was, because we're talking about the statutory mental mitigators.
The extreme emotional disturbance.
That she rejects that based on a number of things, which include that he tells a girlfriend he wanted to know what it felt like to stab somebody, that he cleaned up afterwards, that he, seemed when he went to the hospital after the murder, he seemed completely composed, so that it wasn't like it was in a blind, that they just, that the judge rejected the statutory mental health mitigation.
She rejected the extreme emotional disturbance mitigator, I think based primarily on that letter, this after-the-fact letter by a defendant who wants the death penalty, without even hearing the countervailing evidence, without hearing the testimony of an expert who was in the courtroom and ready to testify that that mitigator existed. I think that's a violation of due process, if nothing else, to come to a conclusion about something
Well,
that
it can't be a violation, in my view. I mean, this is where it's a hard question where it falls. It can't be a violation of the defendant's due process when the defendant knowingly and after being advised that he has this right, waives it. I mean, to me, the only issue on whether Mohammed should be extended prospectively is just whether it results in unequal, disparate treatment of equally culpable defendants or less culpable defendants. But I don't see how it's the defendant's due process rights that are affected when the defendant knowingly waives the right to present mitigation, adamantly so.
Well, I mean, this court has already recognized that despite the waiver, the state has an independent obligation to consider all available mitigating evidence.
But you said it was a due process issue. I'm not sure if that's where it would fall. A due process meaning personal to the defendant as opposed to the court's obligation to ensure that there is some uniformity in the criteria under which somebody is subjected to the death penalty.
Well, I was merely pointing out, Your Honor, that for the trial judge to make a decision about a particular mental mitigator, hearing only one side of the equation, when she's been alerted that there is a countervailing view, is a problem.
So is the problem really that does a defendant really have a right to waive the presentation of mitigation? I mean, it seems to me that we are now caught in a position where we're saying this defendant has this right. But on the other hand, we're saying not really, because the court is now going to, you're arguing the court should be obligated to bring in these very witnesses that the defendant is now saying, that the defendant is saying he doesn't want to present, but the court is now obligated to present them. And so does the defendant really have a right to not present mitigation?
I think that's an excellent question, Your Honor, and I've thought about it too. And based on what the courts, the last 25 years of tinkering with this issue, if you look at Mohammed and you look at the Barnes case, where the trial court clearly has a right to appoint special counsel if the trial court wants to, the defendant's right to some degree is illusory at this point.
When special counsel is appointed, let's take this even further. When special counsel is appointed, is the obligation then on special counsel to actually present witnesses, or is the obligation that special counsel will do investigation and then make a presentation to the court of what that investigation has uncovered?
When special counsel is appointed, my understanding is special counsel presents the testimony. If no investigation has been done to that point, and in many cases there already has been, for example here, there was a full and complete investigation done by defense counsel.
Said they had 24 witnesses, didn't
Exactly, and they were in the courtroom, right there, available to be heard and to testify. And under those circumstances, I would say it was an abuse of discretion not to hear that mitigating evidence. And in Mohammed, when the court said, we are requiring a PSI, I think it was the court's understanding that that PSI would be comprehensive, that that would provide the tools for the court to come to an informed decision.
Did anybody indicate that the PSI wasn't comprehensive, or did they object to it, or did they try to add anything to the PSI?
No.
Okay.
No. But I mean, Your Honor, you folks have the PSI, and it's quite clear the PSI is inadequate, certainly standing beside the full and complete mitigation investigation.
But isn't that's another issue that that isn't specifically raised by you on appeal, which is that in Mohammed we go through in great detail what we expect to have in the PSI, which is comprehensive records, medical records, school records, excuse me, not just a recitation of the bad stuff. And so if this PSI, which I know is in the record and we have before us, was not adequate, that's a different issue than whether standby counsel should have been appointed or the court should have called all the witnesses that were in the courtroom to do what the defendant just said he wanted to waive.
Well, I don't know how one would raise that issue. It's my understanding.
Well, you would raise it the way you just raised on appeal, which is this PSI did not comply with Mohammed.
But this PSI is a typical PSI. This
then
is all
it's
they're
not that-
required to do.
Well, if you read Mohammed, respectfully, I think that is an issue. If it's only just a recitation of what the defendant says and that it isn't more comprehensive, then that's an obligation of defense counsel on appeal to say this PSI did not comply with Mohammed.
Well, I would agree with that, Your Honor. I think it was, I don't know, I mean, this really gets us into the second issue about these PSIs. I mean, PSI is done by a probation officer. These folks are not trained to develop mitigation. I don't know, I suppose they can get records, but they usually don't. I've never seen any medical records or school records or any of that in any of the cases I've handled.
But there's often in PSIs information about the defendant's background. It seems to me it is I've read those that are more than just the defendant's recitation.
Well, that may be. In this particular, it's generally they speak to the defendant and maybe another family member. In this case, they speak to the defendant and generally get confirmation of what the defendant says from a family member, and that's what happened here. I don't know if they have the means or the tools to go back out and get medical records and all kinds of things. One of the things that was missing, of course, was the records from Tara Hall, the boys' home where Mr. Sparre was for several years in his early adolescence or late childhood.
Let me ask you that. I know it's a little off, but when you order a PSI, is it just a matter of calling up and telling the probation officer or whoever is to do it, or do you send them an order outlining what you want in it?
Your Honor,
You don't know? Okay,
I don't know.
Never mind.
It's my understanding the trial judge orders the PSI, that's done by the trial judge, but I really don't know the procedure for that.
But I guess I'm still concerned with, how do we honor a defendant's right, if we say the defendant has that right to not present mitigating witnesses? How do we honor that right, and yet, on the other hand, have information that the trial judge can make a sensible determination about aggravating and mitigating circumstances?
Well, I think you do it just the way I've suggested and the way the court outlined in Mohammed. The trial court has an independent obligation to ensure a fair sentence.
So in this case, the trial judge's obligation, you contend, was to call the 24 witnesses that the defendant had said he didn't want presented.
To call those or have appointed counsel or even defense counsel present the
It
testimony.
doesn't matter who did it, whether it's a standby counsel or the court
Yes.
itself. If the witnesses are called, it's in direct contravention with what the defendant has said he or she wants.
That's true, Your Honor, but we're way past that point. We've crossed that bridge. This court has approved in numerous cases the appointment of special counsel to investigate, develop, and present mitigating evidence despite the defendant's wishes.
So
And
maybe
to
we
some
shouldn't be saying that he has that right.
Well, like I say, it seems to be an illusory right at this point. I don't know what kind of a right.
How is it illusory if he said he doesn't want it? All he has to say, yes, I want it, and he has it.
Well, he can say, I don't want this presented to the jury, but despite that, the trial judge still has an obligation, and the state of Florida still has an obligation to present as full a case of mitigation as possible in order to have a fair, uniform, non-arbitrary, and reliable death penalty
But
procedure.
did the trial judge find any mitigations at all?
The trial judge found some mitigation, yes.
Based upon what?
She found, hold on just a minute. The trial judge found in mitigation.
I think his question was based on what?
Oh,
What
based on what?
evidence was presented
Oh.
to the trial judge that to make these findings?
She found some mitigation, neglect, abuse, a couple of other things based on the PSI and the defendant's statement when he was being interrogated by the police. During his interview, he mentioned some things that happened during his childhood. So the trial judge based her findings on that, but she also rejected numerous potential mitigation, stating, I can't accept it because it was only in a proffer. Now, discretion has to be reasonable, and I don't think that you can disagree that it would be unreasonable, given the trial judge's duty, to consider all possible mitigation and to have a full airing of the mitigation case, not to call these witnesses. There's really no reason not to.
Does Ferretta enter into the analysis of these questions at all, or is, in your view, is it totally irrelevant?
It's my view that it does not, based on this court's decisions in Mohammed and the recent Barnes case. In Barnes, this court, I think, came out pretty clearly in saying that in Florida, the state's interest in reliable sentencing is paramount, and it certainly outweighs a defendant's personal wishes or his desire to die. Defendant has a right to represent himself, but not to choose his sentence, not in Florida. And that, in Barnes, the court referred back to the 8th and 14th Amendments requirements of individualized sentencing. Defendant's wish to die as an arbitrary factor, it should have no relevance.
Well,
in
we've been
sentencing.
struggling with this for a long time,
Yes.
and we got to Mohammed where, I mean, there was a series of cases, including Klukuk, where the judge did put on or have standby counsel or special counsel appointed, and based on what was presented as to serious mental illness, the sentence was reduced to life. My question is, when we adopted the requirement prospectively in Mohammed, since that time, are there any states that have gone farther than we have as far as court-ordered additional requirements imposed when a defendant wishes to waive mitigation? Because it seems like we went, we have, the state has to put on anything they have available. The defense lawyer has to say everything that he or she did to ensure that all the mitigation was investigated, and the judge, a PSI, a comprehensive PSI, has to be prepared and considered, and then the judge has discretion to also, if warranted, have additional witnesses put on. But have any other states gone beyond that, or even there?
Your Honor, to my knowledge, there are two other states that are consistent with Florida, New Jersey, and I think Georgia. At least there's one case where Georgia has said, reliable sentencing really trumps a defendant's right to represent himself or his wish to die. Those are the two states.
And I think in New Jersey, that's what we borrowed what had happened in New Jersey. So have they gone farther in what you're really saying is that in every case where the defendant waives mitigation is that there should be no discretion of the trial court. Trial court must either put on the witnesses or have counsel. And I understand, I certainly
Yes.
advocated for that view, but I'm asking you, has New Jersey gone farther than what happened at the time in Mohammed?
I don't know, Your Honor. I'm not familiar with cases. I don't know if appointing counsel is standard in New Jersey or how it's done there.
I think what concern in this case, because there could be a very compelling case where somebody is clearly extremely mentally ill and yet competent to stand trial. But in this case, you've got some pretty strong aggravators, and as Justice Perry said, the judge did find some mitigation.
There's one aggravator and then the burglary, the technical burglary.
With the aggravator, which was,
HAC.
and I'm not sure why CCP wasn't found. Was it asked for?
No.
Okay. Well, I mean, if and
Your Honor,
and let me just go, there really, in terms of him having PTSD or other types of mental deficiencies, I'm not really seeing that as being the kind of thing that would cry out to have a hired medical expert or psychological expert be called, as opposed to somebody who, had been committed for other reasons and had a doctor that was there prepared to say this defendant has been this way his entire life or something like that, or mentally retarded. What do you say about that in this case? Why this is so compelling to have required any judge to have called these witnesses that were right there?
I think it's extremely compelling. You have an expert who was prepared to testify that both of the statutory mental mitigators existed.
I know, but you understand that there are many, many cases where experts come and testify that there are statutory mitigators met, but it's given not a lot of credibility because of the circumstances of the crime.
Your Honor, how can we judge it when we haven't heard the witnesses? That's the big problem here. I can't comment on the strength of the testimony of these 25 witnesses, nor can this court evaluate it when reviewing this case if we don't have the evidence before us. That is the chief problem before us today, and that's the problem that we've had since Hamblen was decided. This court has recognized that. Without the facts developed and presented on the trial level, this court can't conduct any sort of proportionality review. I couldn't even raise proportionality in this case because I don't have the testimony. I don't have the evidence. I can't argue that the trial judge was wrong because the countervailing evidence was never presented to the judge. She rejected it out of hand without even hearing the testimony. And I don't think that comports with what this court has said is the primary interest in this case, which is reliable sentencing, death penalty sentencing. And
You are in your rebuttal time.
okay, I'll save mine for rebuttal. Thank you.
May it please the Court, Assistant Attorney General Charmaine Millsaps for the state. This court has already rejected these arguments in Grimm and in Russ. First of all, in Grimm, you held that a defendant who's waived mitigation may not complain on appeal about the fact that they did not call, in that case, Dr. Larson as a witness. So I think Grimm says that if you waive it below, you basically waive an argument that the expert should have been called as a court witness.
But if that were the case, Mohammed would have never existed because he waived mitigation. We found reversible error by the judge giving great weight to the jury's recommendation. But my question really is, looking back at Mohammed, which was a step at that time, we did vest judges with discretion to determine whether witnesses should be called or counsel appointed. Question is, I was looking in Mohammed, there has to be some guidelines to guide the judge's discretion. Again, we have a case tomorrow where the judge did appoint counsel to present mitigation. So what is, if we were going to tell judges in capital case courses, what is to guide their discretion as to whether they're to appoint counsel or call the witnesses as their own? What would you say?
Well, Your Honor, she's not advocating for discretion when you argue that the court must hear from the witnesses. You're arguing for a rule of law.
I understand, but I'm asking you. I mean, the first issue was that the judge abused her discretion. So what I'm asking you is, and asking because I'm not sure I know the answer, as well as I'd like to hear the state's position on it, because the state has an interest in making sure that the death penalty is not imposed arbitrarily, is what should guide this discretion. This judge says, no, I'm not going to present or I'm not going to call this witness, and another judge says, based on the exact same facts, I am going to, since they're right here, I want to hear from one or two of the mental health experts. What's to guide the discretion? Is it just a flip of the coin?
Well, but Your Honor, you need, especially in this case, what you're saying is you would just call Dr. Kropp. Well, no, we're also going to, if the defense calls Dr. Kropp, the state is allowed to call its own mental health witness. Of course, you're going to be holding an entire penalty phase.
Well, but there are you admit that there are cases that have, I don't know if they're half of the cases where the judges are allowing or appointing counsel. I don't know what the numbers are, but the state at that point we've already crossed the point where that would be reversible error for them to have appointed special counsel in violation of Ferretta. So
okay, but
what
for
is,
example,
I'm still trying to ask you the question, what should guide the judge's discretion?
Well, Your Honor, I don't think they should be calling these witnesses as court witnesses. But I think you're missing the point in Grimm. In Grimm, he did appoint special counsel, but they listened to they got the mental health expert to do a written report. Your Honor, if you really, I think what you should do more of this is on written submissions. Her real argument here, Your Honor, which you rejected in Russ, is when defense counsel puts forward a Kuhn colloquy, that all that information, which is a proffer, and you pointed that out in Russ, it's not evidence, it's a proffer. What she's saying is everything presented during the Kuhn colloquy should be accepted as mitigating evidence and found by the trial judge. And all those witnesses should be called. In effect, Your Honor, that would have the exact effect of, at least as to the judge, holding that you cannot waive mitigation. Because she wants all 25 of all 24
So if you were,
witnesses.
again, I guess what I heard you say was it would be wrong for the judge to call witnesses as his or her own court witnesses, even though we approved as that being one possible way to approach this in Mohammed. You're saying we should recede from that portion of Mohammed?
Now, parts of Mohammed, for example, you should not give great weight to a jury's recommendation of death. That, in fact, was a one-sided presentation. So that part of Mohammed, I certainly agree with that. But, Your Honor, the other thing, I think where you need to go is more, if you're going to do this, you need this more at the PSIs and written reports. For example, here the judge could have said, well, I'm not going to call Dr. Kropp, but do you have a written report from Dr. Kropp? Okay? And so, because, Your Honor, usually to answer your question, what a judge usually does is order a PSI, but not a particular type of PSI. For example, in this PSI, they relied on the grandmother. They did not get the medical records. The defendant here was administratively discharged from...
So isn't that a violation of Mohammed? Now, it hasn't been raised, but Mohammed... I have Mohammed in front of us, and it says
But, Your Honor, I'm
specifically-
telling you that part doesn't work. Because that's not, judges plain just order a PSI. They do not order, oh, you know, I want a minor PSI or a real PSI or an extensive PSI. They plain order a PSI. And the better way to get this information, if you ask me, is to have the doctor submit written reports straight to the trial judge. I don't understand doing it through the PSI. What they should have done here is exactly what happened in Grimm, which is have the mental health expert not testify, but submit the written report. Now, maybe Dr. Kropp in this case didn't have a written report, in which case the trial judge should have said, well, I want one.
In the Mohammed line of cases, you consider the PSI mandatory, correct?
Yes, Your Honor.
And you consider that whomever is done an investigation about the mitigation, is that a mandatory step?
No, Your Honor, because under Russ, you rejected that.
Okay, so that's
What you're
never a
saying-
step. So then we have different classes of cases, those where there is defense counsel, but there's a waiver. Is there not a mandatory requirement that defense counsel do an investigation of
Yes.
mitigation? Okay.
And then he puts
So that's a class of
Kuhn
cases.
proper.
Oh, no, I understand.
And
So
but the-
just please, let me finish. I'm trying to see where we're going here, because we're apparently having two classes of cases presented now in our capital litigation. If there's counsel, then there's a mandatory look at mitigation by defense counsel, mandatory, and disclosure of that to the court, correct?
And under your Kuhn line
Right,
of
right.
cases.
Well, I mean, they're all flowing in together. If there is no counsel present, then that's a step that's missing from those in which there's no counsel then.
There's always counsel present, Your Honor. Any-
Representing, Ms. Millsaps, you understand what I'm saying?
No, I do not.
Okay. In one case, you'll have an attorney representing a defendant who just refuses to put on mitigation, correct?
Yes, and
And
then you
under
do-
that situation, this court's opinions require that counsel investigate mitigation and disclose it to the court, correct?
so that the defendants.
So is that
under
correct?
Kuhn- Yes, under
And if
Kuhn.
there's no counsel representing the defendant, not standby, but no counsel representing a defendant, that's a step that's different.
Yes, if he has
So we have
asserted
two
his
diff-
Faretta rights. If he has asserted his Faretta rights and is representing
So
himself.
we have two different classification of cases that proceed forward.
But
We have
that's-
those in which there is an attorney present, so you can evaluate, at least a judge can look at what's proffered and come to some decision as to what, if something else should be done. But if there's no counsel present, that's a step that's missing and different from a non-represented defendant.
If a defendant represents himself
Self.
under Ferretta, we would
And
not do a
is that a
Kuhn.
viable, and is that a constitutional difference, or one that causes a constitutional problem with that difference in that approach? Before sentencing, if you have a lawyer, the judge is going to, if you waive mitigation, the court is going to hear at least a proffer of mitigation. If you're representing yourself and you've waived it, there's no way a judge can ever know what the mitigation is in a similar fashion.
Yes, a defendant who's represented himself, Your Honor.
And then that's
I
what
just
I'm
didn't
asking, is that
understand
create
your
a
question.
constitutional problem?
No, Your Honor, because that's what Ferretta allows them to do.
And that's because of Ferretta.
Yes, Ferretta allows them to represent themselves. And a Ferretta, let's call him a pro se, because that's what he is not going to do a Kuhn colloquy with the judge. That's what you do to ensure his waiver.
Well, isn't the Kuhn colloquy and all that is involved in Kuhn designed to ensure that the waiver is knowing and is well-informed?
Intelligent, knowing that the defendant's waiver of mitigation is knowingly and intelligently, intelligent and fully waived. Yes, you're doing it for the purpose of giving him the background. Here is what I would present. And then you turn to the defendant, exactly what happened here, and said, do you understand that's what counsel would do? And do you want that waived? It is for the purpose of making his waiver voluntary. That is what you're doing Kuhn for. Now, when a defendant represents himself, Your Honor, and that's just we don't do there is no Kuhn equivalent
No, I
to a pro
understand.
se
I'm not
defendant.
questioning that. I understand that's the difference. But it is a significant difference if the mitigation is at least proffered to a judge. You're asking what controls discretion. It would seem as that would be one of the factors in discretion, that if you're represented by counsel and that attorney presents the most horrific case of mitigation you've ever seen, there's a method to evaluate discretion on whether you appoint someone or not. And on the other hand, if there's no counsel, that's never disclosed, so there's no way, there's no objective way that a trial judge has to, or we have to evaluate the exercise of discretion. There's no parameter to it. Is there?
But, Your Honor, remember, if you do it in the pro se defendant's context, you're truly violating Ferretta.
Well, I understand. I understand that. This is the dichotomy that we're
Okay.
into.
And
my
also-
question is, though, is that these cases then end up in a different posture with regard to the discretion.
Pro se defendant's cases end up
Yeah.
differently.
Well,
Yes,
but
they
there is, for all cases, since Mohammed, a requirement of a comprehensive PSI that is to be meaningful, should include previous mental health problems, including hospitalization, school records, and relevant family background. Now, if that is not being done, then that is a problem with compliance with Mohammed, and that we need to instruct judges on. But further, as to the two classes of defendants, we then have the defendants who, everyone gets a PSI, presumably comprehensive, and then in some cases, judges are calling witnesses or having counsel present mitigation, and in others, they are not. Now, I'm still trying to get to what is to guide that judge's discretion. Once they get the PSI, the witnesses are there, as to whether they then appoint counsel, because is it that there is a probability of significant mitigation that the judge is concerned about is not being presented. That's what we what we are talking about in Mohammed, that is the probability of significant mitigation. Now, Ms. Carey is saying in this case, there was a probability of significant mitigation, and the judge abused her discretion by not calling witnesses. Can you respond to why that's not a violation of Mohammed? Why was it in her discretion not to call witnesses if there was a probability of significant mitigation? Or is the state saying this was not significant mitigation, these were just some hired mental health? I mean, let's get to this issue here. Why didn't this judge abuse her discretion in appointing counsel or calling these witnesses?
The latter, and for two reasons. I'm saying there wasn't significant. Dr. Kropp's diagnosis is
Well, that's the first time. Now we're getting to what, that's why I asked you what should guide the discretion, and you kept on telling me nothing guides the discretion. This is not a workable case. Mohammed's not workable. So you're saying if you look at Dr. Kropp's, his report, because the report's not in evidence. No,
there's no report. Okay.
In Mohammed, did the court say what should guide discretion of the judge?
No, Your Honor.
Has this court ever said what should guide the discretion?
No, Your Honor.
Did discretion mean discretion?
Yes, discretion cannot be must here because it's no longer discretionary if you're going to make a rule must here. But let me also go back to, and I think this case highlights it, what are you going to do when you call somebody like Dr. Kropp and it ends up going south? Because here, one of Dr. Kropp's diagnoses, his 5 possible diagnoses, one of them was intermittent explosive disorder, which is very easily rebutted by cross by the prosecutor's part. And secondly, as part of his interviews, he admitted, the defendant Sparre admitted to shooting dogs and running over cats with lawnmowers. And what's more, Your Honor, is you cannot do just these 2 steps. Not only do we cross Dr. Kropp on that, but if you want full mitigation presented, then you're going to have to allow the state to call its own expert that could end up with antisocial as the diagnosis here. And so this also has not only do I believe that this was not significant mitigation, Your Honor, the diagnoses were post-traumatic stress disorder from being in the boys' home. But secondly, Your Honor, you're going to have to face the serious downsides of when you call these experts on their own. One of the diagnoses and the torturing animals would come out, and then the state gets to rebut all these things. So you could very well end up with a case in mitigation that looks more like a case in aggravation, that you have forced the defendant in violation of FRERETA to present. And Your Honor, I would like to go back a little bit to your question, because I don't think it's quite as divergent as you may think, because under Russ, you all said what was in the Kuhn colloquy is not evidence, it's just a proffer. And the trial court did not violate Mohammed by not taking all the information in the Kuhn colloquy as mitigation. Okay? So under Russ, you've already rejected that the Kuhn inquiry automatically establishes mitigation or is somehow
I mean, there's
a
no way you
source.
can establish anything other than evidence properly admitted. I mean, that's for sure. But going back to the case, I still haven't had that I heard is a full answer as to what was the mitigation. Was that the only thing? The post-traumatic stress? Because he sort of started going everywhere.
There were 5 diagnoses.
And what do you believe those to be?
Post-traumatic stress disorder, intermittent explosive disorder, AAHD. There was substance abuse was the 4th, and bipolar schizoid affective disorder. Okay, now the other 2, that's Dr. Kropp. The other 2 experts, were Dr. Allagood and Dr. Greenberg, were going to testify solely regarding the post-traumatic stress disorder. And they said it was dating from the defendant's time in the boys' home, Torah Hall, when he was 11, 12, or 13.
And these were disclosed now?
I'm reading from the Kuhn colloquy, Your Honor.
Okay.
This is what, but that is a proffer, not evidence. It doesn't violate
understand.
Muhammad.
Didn't the
And
judge find some of that as non-statutory mitigation?
they did, Your Honor. The judge found, I would say, 4 things that found 13 non-statutory. That's why I think this is harmless anyway in this case. The judge found, she found age as a statutory mitigator, and then 13 non-statutory mitigators, including things like the defendant had been neglected. I think 2, 3, 4, and 6 were in fact found from this. Really, she got it from the Kuhn. In other words, why she didn't really follow Russ, she did it in the defendant's favor. She basically took a lot of that from the Kuhn colloquy and found it as non-statutory mitigation. So look at number 2, number 3, number 4, and number 6. And then Dr. Buffington, who was a pharmacologist, was going to testify about his long-term drug use. But the defendant admitted during the confession that he took the pills out of her purse after he killed her. He was not on drugs at the time of this offense. So Dr. Buffington's testimony isn't going to help you one bit because it's after the fact. He takes those pills from the victim's purse on the way out.
But that doesn't necessarily negate the fact that he may use, you were talking about long-term use, you're just talking about at the moment of the offense. But wasn't his testimony going to be more of a long-term use of drugs?
And alcohol abuse, Your Honor.
Right.
That's true. And yes, those could be, but we're talking about significant mitigation. Your Honor, I took Mohammed to be the following. When there is a real possibility of something like the Kalkluk case, where the defendant is significantly mentally impaired, you're not doing it for minor mitigation. You're doing it for substantial mitigation. There's a good argument that we shouldn't even be talking about Mohammed here because it just doesn't rise to that level.
So how do you make the determination prior to hearing the witnesses of what is substantial mitigation and what isn't? This whole area is sort of, in my mind, a bit convoluted. So how does the trial judge even make the determination as to, is this significant enough that I should call witnesses or not?
Well, Your Honor, that's why I think you're asking me what we could do to make this better, and I personally would have asked for the mental health expert to generate a report. Your Honor, for example, if there's no report...
Let me ask you then, if you generate the report, what do you do with it? Does it come into evidence, or does the trial judge just read it and make some findings? What do you do with the report? I mean, how is it different from, if you're going to accept it, how is it different from accepting the witness?
Well, for the exact same reason you would do the PSI. It would depend on yes, the first thing you do is read it. And then the second thing you do is decide if the diagnosis is serious enough to be substantial. Your Honor.
Would you have to have the state to submit a report also?
Yes, Your Honor. If we have an expert.
Wouldn't the defense have a chance to rebut that?
Your Honor, and
I
then
mean,
you
it's a quagmire we're setting up.
Yes,
here.
yes, you are. You're getting in.
What we should do, in essence, is simply say, you must have mitigation presented, whether you want it or not.
But you can't do that because
I
that
know,
violates
but that's the only real answer.
Yes, and that's the real quagmire here.
Can I ask a question just to clarify something for me? Maybe I misunderstood when I heard it earlier, but there were 2 aggravators in this case, am I correct?
Yes, Your Honor.
HAC
Yes,
and during the course of burglary.
yes.
I thought I heard earlier there was just 1 during the course of burglary.
No, Your Honor, I said one mitigator, that was a statutory mitigator.
No, I heard it, I'm talking
no,
during
they
Ms.
were
Carey's
two.
argument.
HAC was definitely found, there were two. And there were two aggravators here, Your Honor. They were both given great weight, but one of them was definitely HAC. This victim was stabbed over 80 times, and she had over 30 defensive wounds. And he basically killed her for the rush, the thrill of doing it, which is the other problem here. We've got the defendant's own testimony as to what motivated this murder. He gave a confession, and then he wrote a letter saying that. And the trial court relied on that in part to reject the mental mitigation. But yes, Your Honor, it is a quagmire. I'm not trying to minimize the fact that it's a quagmire, but you cannot get out of the quagmire by violating the Sixth Amendment right to represent yourself. That's not a way out of this dilemma. And a lot of the solutions proposed, especially by opposing counsel, do just that. They violate the Sixth Amendment right to
But you're
counsel.
suggesting that if first of all, reinforcing the PSI requirement that when this is not to be an ordinary PSI, it's to have records, but then also require submission of the report, so then the state gets to submit the report. Many times it's the state really, and we've said has the obligation to give mitigation. So if you had a situation where there had been a diagnosis of a mental retardation, I mean, as an extreme example, the state, has that obligation to make sure that's presented to the judge in these situations.
I think that's a Brady obligation. No, that's not a Mohammed obligation. That's beyond Mohammed.
But I thought we
That
said
would be
in
a
one of the
Brady.
cases pre-Mohammed that the state has that if they've got mitigation, I've seen in many cases the state make sure that anything in the record that they have is also put on. And you're saying that's under Brady, not under the...
Well, the mental retardation. No, for example, let's take the Terra Hall school records here. That wouldn't be Brady, but that may well be under but the
So if
report
the
I
state-
was referring to, Your Honor, was if they introduce Dr. Kropp's report, we're entitled to hire an expert and put into the record our report as well. So, that's the other problem here. I'm hearing some going toward unrebutted mitigation, and that's accuracy means whether what comes out is good or bad. And if you're going to say the Eighth Amendment trumps the Sixth, which I think the United States Supreme Court would disagree with, but accuracy is accuracy, and you need it from all sources, whether it helps or hurts the defendant. You cannot do one-sided or one-way mitigation presentations. There's no justification for that. So I'd like to sum up now. I do not think that the Kuhn colloquy is anything but a proffer. It's not evidence, so the judge did not abuse her discretion by automatically accepting it. I think you've rejected this in Grimm. You rejected why the mental health expert the report was introduced. Dr. Kropp was not, Dr. Larson in that case was not called as a court witness. I think it was also harmless in this particular case. And no, you should not recede from Hamblen because you'll be violating the Sixth Amendment if you do. Ferretter and McCaskill allow the defendant to waive mitigation. That is he has a right to do that. And so the trial court here did not abuse her discretion in her treatment of mitigation, and you should not recede from Hamblen. Thank you for your time.
Thank you. Rebuttal?
Yes, Your Honor. It's been 25 years since Hamblen, and when Hamblen was decided, we didn't have a history. We have a history now. And what that history has revealed is that appointment of special counsel works best. Judges do that in cases already. The court has found that that's not a violation of Ferretter right, and if the court wants to ensure uniform, non-arbitrary sentencing and death penalty cases, that's a solution to the problem. What we want is to present the sentencer as full a complete a case of mitigation as impossible. And listening to all of us today, I feel like we're going down the rabbit hole. The solution is right there. Require appointed counsel in every case. There's absolutely no reason not to. It doesn't take anything away from trial courts. It doesn't place an extra burden on trial courts. And frankly, I think trial courts would welcome it. Their job is to make a decision with as much information as possible. And if appointed counsel is represented to either investigate and develop mitigation, if it has not been done so, or to present the testimony if by this
So
court...
you think that appointing an attorney in every case to present mitigation is, and that can stand beside the fact that the defendant has the right to not present mitigation?
The court has
Those
already...
two wait a minute, I'm just...
Sorry.
You're still asking us to go even a step further and say in every case, there should be an appointed counsel to present mitigation. Can those two things stand next to each other?
Yes.
Or are we just giving lip service to a defendant having a right to not present mitigation?
I do believe it's giving lip service to that, but that decision has already been made.
But now you're asking us to take it even further.
Well,
so
what I'm suggesting is that it not be arbitrary. In other words, what's happened is in some cases, judges appoint special counsel. In other cases, the judge decides, I think I want an evaluation from this expert, or I think I want to hear this family member testify.
So that's done on a case-by-case basis.
Yes, so what we
where
have-
the judge can exercise some discretion as to whether or not they think it's necessary, is it not?
And the only thing that guides the judge's discretion is what's in their head. There's no way for the court to review whether what the judge has chosen might be significant mitigation. Is the only significant...
I thought you said the trial courts would welcome the fact that if we require them to appoint
Yes,
counsel.
I do.
Well, they have the discretion to do so already if they wanted to.
Well, that's right, but they're not using that discretion as this
So
case
they must not be
indicates.
welcoming it then.
Well,
Yeah.
Your Honor, they haven't been told that it's necessary, and I think that's what's required here.
Well, it seems to me, again, for this case, we have the case tomorrow where the judge did appoint where I think the person had been committed for insanity based on animal cruelty, that there is a difference, despite what you say, between these experts, like a Dr. Kropp, who is hired and kind of reviews things and says this person has PTSD, which because he was in the boys' home, versus somebody that has had a lifelong history of a diagnosed mental illness. I see a qualitative difference, like a Klukok case, where that was the case. So why wouldn't the issue here be that there was not a probability of significant mitigation based on what was proffered? These were witnesses hired not based on anything that it had been diagnosed in his past. Why wouldn't that be a good dividing line for whether the discretion was abused?
There were 4 experts.
But they also, it sounds like they were saying the same thing, drug abuse, PTSD.
No.
Not to minimize that, but that certainly isn't the kind of mitigation that is going, in my view, respectfully, mitigate this crime, which was a pretty horrendous crime.
Your Honor, they weren't all the same, and I think Ms. Millsap misrepresented. Dr. Kropp was going to testify about 5 psychiatric diagnoses stemming from his childhood as a result.
Were they in the records?
Of his childhood.
In the childhood records, there were
Based on his-
psychiatric
based on-
diagnoses?
I'm getting to that later, based on his evaluation. Dr. Buffington, I think we talked about Dr. Buffington, the effects of long-term drug and alcohol abuse since this person was 11, 12, or 13, particularly the effects on the frontal lobe. Dr. Alligood and Dr. Greenberg were to testify to a history of mental health issues dating back to the age 11, 12, and 13, when he was in the Terra home for boys. They were not solely going to testify about his PTSD. What they were going to talk about is the lack of treatment for PTSD. So this was significant mental mitigation that covered the span of his lifetime from age 11 to age 19. He was 19 when the crime was committed. So this was significant mitigation. I don't think it could be considered anything other than significant mitigation. Whether it's sufficient for this court to say death is not the appropriate penalty, I don't know that. But the court can't make that decision without hearing the testimony and without considering the evidence. And if the concern is fair, reliable, and uniform sentencing, this is the way to do it. Appointment of special counsel to find and present whatever mitigation is available. This ensures that someone who's trained to do so will do his best to locate and present whatever mitigation exists. This preserves the adversarial system of justice, which this court recognized in Clocott was important to appellate review. Surely it's more important to getting the information and the facts at the trial level.
Your time has expired. Thank you for your arguments.
Oh,
Yeah, you're 2 minutes over.
thank you, Your Honor. I appreciate it.
Thank you. Court is adjourned.
All right.